As of today, 20th November 2025, it is correct that Federal High Court in Abuja, presided over by Honorable Justice James Omotosho, has convicted Mazi Nnamdi Kanu, leader of the prescribed Indigenous People of Biafra, IPOB, on 7 terrorism-related counts and sentenced him to life imprisonment with additional terms on some counts to run concurrently. This development has understandably generated intense reaction across Nigeria and in diaspora, particularly online, where it is now a trending issue. What follows is my personal opinion as a Nigerian lawyer and a citizen of the Federal Republic of Nigeria, not as a counsel in the matter and not as an advertiser for any person or group of persons or organization. I will confine myself to the facts in the public domain and to broader legal and constitutional issues raised. What are those issues? Let me walk through the issues. Number one, the facts we must first acknowledge from the reports of reputable local and international media that I've read through. The Federal High Court, Abuja, has found Mazi Nnamdi Kanu guilty on all 7 terrorism-related counts brought by the federal government under the Terrorism Prevention Act. The court held that his broadcasts and directives, including issuing an enforcement of a sit-at-home order in the eastern part of Nigeria, and threats against security agencies and civilians, constituted acts of terrorism and incitement to violence, leading to serious loss of life, economic disruption in the part of southern east of Nigeria. The prosecution reportedly asked for the death penalty, but the judge opted for life imprisonment, expressly noting global disapproval of capital punishment and stating a desire to tamper justice with mercy. Separate reports show that his legal team has rejected the judgment and announced an immediate appeal and reactions from political, religious, and civil society figures. In addition, the judgment comes at the end of a long and tortuous legal journey. Arrest in 2015, if you can remember, that was when this matter started, and a bail in 2017, flights from Nigeria after a military operation at his residence, and the controversial rearrest in Kenya, and return to Nigeria in 2021, described by many people as an extraordinary rendition. A 2022 Court of Appeal decision, which condemned the rendition as illegal and initially discharged him. Later, it was overturned by the Supreme Court in December 2023, which held that although the rendition was unlawful, it did not deprive the federal government the authority to prosecute. The Federal High Court has the jurisdiction to try him. Recent proceedings in which Mazi Nnamdi Kanu, having sacked his legal team, chose to represent himself, refused to call witnesses, and maintained that the court had no jurisdiction over him and that the terrorism law was invalid. Objections which the trial judge has now dismissed. These are the objective building blocks for any serious discussion. Please note, as a lawyer, key legal and constitutional questions that will be raised on this. I want to walk you through key legal question, constitutional question. Number one, the provision of extraordinary rendition and the rule of law. It is now judicially recognized at the appellate level that the manner of in which Mr. Nnamdi Kanu returned from Kenya was illegal and violates the international and municipal law. The Supreme Court, however, adopted a position similar to Ken Fishby doctrine in the United States of America, namely as illegal method of bringing a suspect before the court, though condemnable, does not necessarily rob the court of jurisdiction to try offences properly within its remit. As a lawyer, I must be candid. On black letter law, the trial court has followed the binding authority of the Supreme Court. You know, when Supreme Court gives judgment, it's supreme over every other judgment. And the trial court followed it. On principle, the constituted and the continued tolerance of extraordinary rendition weakens public confidence in our justice system. When the state violates its own law to secure a suspect and later secures a conviction, many citizens will feel that the process, though technically valid, is tainted morally. A constitutional democracy cannot be strengthened by sending the message that ends always justify the means. The state should not be allowed to break the law in order to enforce the law, especially in high-profile political and ethno-religious cases. Also note, fair hearing, self-representation, and the conduct of the defense. Reports show that Nnamdi Kanu elected to dispense with his team of senior counsels and took over his own defense and then refused to call witnesses or lead evidence, insisting that the entire process lacked legal foundation. You can see the way the whole thing went through. The trial judge has now held that the court gave adequate opportunity for him to defend himself, which he never did. Having chosen to ignore that opportunity, he cannot turn around to claim denial of fair hearing. Once you are being given an opportunity to defend yourself, if you foreclose your rights, who is to be blamed? In strict legal analysis, that position is inconsistent with long-standing in Nigerian case law. The court is obliged to provide an opportunity for you to defend yourself. It is not obliged to compel a defendant to use it. So it's a choice. It's a matter of discretion. You may wish to foreclose. However, as a practitioner, I must say that in politically charged cases of this magnitude, where issues of life, liberty, and national security intercept, courts and counsels alike must bend over backward to ensure that the right to defend is real, not merely theoretical. Once an accused person begins to represent himself in a complex terrorism trial, red flag should go up. The danger of an appeal based on technical fairness versus practical fairness becomes very real. Terrorism, speech, and political agitation. Look at it. The judgment appeals to treat inciting broadcasts, threats, and the violent enforcement of the sit-at-home order as an act of terrorism, especially where they are linked to killings, attacks on security personnel, and synthetic disruption of the civil life and commerce in the southern eastern part of Nigeria. The legal and moral position, in my view, is this: peaceful agitation, self-determination, rhetorical and political criticism are protected or ought to be under our constitution and the international human rights instruments. Take note. However, when agitation crosses the line into explicit threat of violence, orchestration of attacks, or endorsement of terror tactics, the law is entitled, indeed obliged, to intervene. As a lawyer, I do not support violence. I do not support violent enforcement of political ideas from any side, whether from the east or west or north, whether from state actors or non-state actors. The blood of any Nigerian, whether in the southern east or anywhere else, should never be the price of political expression. As a citizen, does life imprisonment solve the problem? This is the question we should be asking ourselves now. Prosecutors asked for the death penalty. The court chose life imprisonment, discretionary. The judge expressly referenced global trends against capital punishment and a desire to tamper justice with mercy. From a citizenship standpoint, several questions arise. What are those questions? Will this sentence reduce or escalate tension in the southeast? This is the question. Early reactions indicate sharp divisions and warning that decisions may inflame grievances and deepen mistrust between the region, southern region, and the federal central. Are we addressing symptoms while ignoring causes? You need to look at the causes of the symptom. For years, multiple stakeholders, traditional rulers, religious leaders, southeastern governors, and civil society organizations have pleaded for a political solution or a more restorative approach to this crisis. Dialogue, amnesty frameworks, demobilization of armed groups, and concrete socio-economic interventions. What message does an indefinite custodial sentence send to younger, more radical elements? History, including our own Civil War experience, teaches that imprisoning or even executing leaders does not always extinguish ideas. Ideas are there. Sometimes it mythologizes them and pushes movements into darker, more aggressive, more decentralized, and more violent forms. I am not suggesting that courts should decide cases based on fear of street reaction. No, far from it. But statesmanship requires that legal victories be complemented by political wisdom. A life sentence may satisfy the letter of the law. Yes. It does not automatically heal the underlying political wound. It's still there. Selective justice and perception of imbalance. Look at this. Selective justice and the perception of imbalance. One of the greatest danger we face as a country is the perception of selective justice. Citizens always see many individuals across various religions and political sects openly issuing inflammatory, divisive, and even violent statements, often without consequences. When the hammer falls most decisively on one high-profile separatist leader, a narrative of one law for some, another for others, it becomes almost inevitable. And that's what we are seeing today. Whether that perception is objectively accurate or not, it is politically toxic. The antidote is consistency. Follow consistency in everything. If speech crosses into incitement or violence, is to be treated as terrorism, then that standard must be applied evenly. Whether the speaker is a separatist, a politician, or a religious leader, or any influential figure, it doesn't matter. Whomever treats equal. The integrity of our justice system depends not only on the correctness of individual judgments, but on the pattern that emerges over time. So note that it's not about giving one judgment. The appellate process and the need for restraint. As a matter of fact, this is not the final word. The defense has indicated that it will challenge the conviction and the sentence at the Court of Appeal. And if necessary, to the Supreme Court, which I believe is the last resort for a common man. The same constitution that empowers the trial court also provides for a hierarchy of appeals and potentials for presidential prerogative of mercy in appropriate circumstances. Who knows what will happen later? As a lawyer, I must emphasize this. Those who support the judgment and those who oppose it must alike respect the judicial process and exercise restraint in their reaction. Don't be sentimental. Court is court, and we must obey the rule of law. Peaceful protests, robust debate, and critical commentary are legitimate. Violence, intimidation are not at all. It's illegal, no matter how, whatever you try to disguise it. Security agencies, on the other hand, must enforce law and order firmly, but with strict respect for human rights, especially in the Southeast, where emotions are running very high. We must not allow this judgment to become an excuse for collective punishment of ordinary citizens in any part of Nigeria, please, because that's what you are going to see next. Beyond the courtroom, what Nigeria must learn from this case, let me walk you through. Whatever one's view about Nnamdi Kanu or IPOB, This case forces Nigerians to confront certain uncomfortable truths. Grievances cannot be permanently suppressed by force alone at all. Aggregation of marginalization, abuse by security forces, and structural insecurity in resource allocations and representation must be addressed substantively and not only rhetorically, because that's actually the genesis of all these things. Our criminal justice architect badly needs reform. We must reform our criminal justice architect. Long pretrial detention in DSS custody. Long pretrial detention in DSS custody. How do you see it? How does it look like? Endless adjournments and the interlocutory schemeless and the unnecessary delays. The recurring temptation to treat politically sensitive suspects as exemption to ordinary constitutional safeguards is a question of concern. This pattern damages public trust and creates fertile ground for conspiracy theories. You see people doubting the judiciary. You see people doubting the security agency. The line between security and politics remains dangerously blurred. Security agencies must never become instruments in purely political battles, just as political actors must not cloak purely partisan objectives under the banner of self-determination or defense of our people. We need a coherent national policy on non-violent conflict resolution. Nigerians should by now have robust mechanisms for structured dialogue, truth-telling, power-sharing negotiations, and carefully designed amnesty, or the radicalization programs, rather than launching from one security operation to another. My considered position in this matter as a lawyer and as a Nigerian citizen, bringing all this together, my position can be summarized as follows. So you take note my point of view on this as a lawyer and as a Nigerian citizen. Respect for courts, but insistency on scrutiny. Very important. Respect for the courts, but the insistency on the scrutiny. I respect the institutional authority of the Federal High Court and the right of the judge to reach findings based on the evidence before him and binding appellate precedents. At the same time, I strongly support rigorous appellate review of both conviction and sentence, given the profound legal and political implications. Unequivocally, rejection of violence from all sides, whether from the southeast or from anywhere. I do not endorse violent method at all. It is not advisable. It's not the best way to go. Whether allegedly deployed by non-state actors in the name of IPOB or by state actors whose operations may have resulted in extrajudicial killings, torture, or dispassionate use of force. The rule of law must restrain both the citizen and the state. We must respect the law. Life imprisonment should be a measure of last resort. In a multi-ethnic federation with history of civil war, sentence of life imprisonment for a prominent separatist leader is not a mere legal footnote at all. It is a political earthquake. Yes, I believe our legal system should always ask whether a combination of strong but finite punishments, robust supervision of, and as well as political engagement could achieve justice and national healing more effectively than a purely custodial, open-ended sentence. Look at it. The truth, I want to talk, the true test is what we do next as a country. What do we do next as a country? If we use this judgment as excuse to gloat, stigmatize, and further alienate an entire region or a group of citizens, we will store up deeper crisis for the future. Deeper crisis for the future. If, however, we use it as a sober reminder to address historical grievances, strengthening institutions, reform security practices, and reaffirm equal citizenship for all Nigerians, then some good may yet emerge from a painful episode. A call for calm reflection and responsible engagement. Very important. To those who feel outraged by the judgment, I understand your pain and your sense of injustice. Yes. I urge you to channel that anger into lawful, peaceful advocacy, into supporting competent legal representation on appeal, because there's room for appeal, and into a constructive civic engagement. Don't resort to violence or force. To those who feel vindicated by the judgment, I urge you to resist triumphalism. Don't start jubilating. The goal of justice is not to humiliate or permanently crush political opponents. No, at all. It is to protect society while preserving our shared humanity. Very important to note that. All right? To the Nigeria as a state, having secured a conviction at the first instance, the real mark of maturity will be in how you handle the appeal, the legion, and the broader political fallout with restraint, fairness, and openness to dialogue, not with collective punishment or indiscriminate repression. It's not advisable. To all Nigerians, including myself, sitting before you here, this is a moment to think deeply about the kind of country we want to build. A country where grievances are addressed through credible institutions, where no group feels permanently condemned to the second-class citizen, and where neither separatist violence nor state impunity has any moral or legal space to flourish. In conclusion, take note, the life sentence of Nnamdi Kanu is a watershed in our constitutional history. As a lawyer, I insist on due process, the right of appeal, and strict adherence to the rule of law. As a citizen, I insist on justice that is not only legal, but also perceived to be fair, proportionate, and even-handed. Only on that foundation can Nigeria move from perpetual crisis management to genuine national building. Let this be an eye-opening to us. Let us reflect on this presentation. Let us look at it. This is my honest, genuine, simple opinion from my own perspective, from my own understanding. As a lawyer and as a Nigerian citizen who has the freedom of speech, and I will say things the way I see it. If you have any question, if you have your comment, if you have reaction, drop your comment on the comment section. Let's hear from you. We want to share knowledge. I want to learn from you. We want to continue to read the press. We continue to read, and things will continue to unfold. But please do not resort to violence. Always stay tuned for more updates, more insights, more opinion. Any issue that touch me, will come out here and address it. And for more videos like this, don't forget to subscribe to my YouTube channel and follow on my social media platform so that I continue to get more opinions like this. Drop your comment on the comment section and let's interact. And also don't forget to share this video. If you wish to share it to the audience, let's have more engagement and let people react, and let's look at where we're heading. I wish a better Nigeria, and God bless Nigeria. Thank you.